On this episode of the show, we're going to talk about whether or not inherited property is separate property or community property.
Creating wealth, protecting families, building legacy. This is the Rich Life Lawyer Show.
Hey everybody, this is episode 43 of the Rich Life Lawyer Show. I'm your host, Christopher Small. I'm super pumped to be here with you today to answer a question that I get relatively frequently, and I got today. So I wanted to talk about it and answer it with you guys because I think it's something that is important to know, especially if you happen to fall into this situation and are curious. So I was talking to somebody today and they were telling me that they were wanting to leave a lot of their property to one of their kids, but they were worried because their kid was married to someone, they were separated, they weren't going to be together, but she didn't know if they were ever going to get divorced, and she was concerned that if she just passed her stuff down to her kid, that the spouse that she didn't like would somehow have an interest or retain or get an interest in that property. And she was concerned about that. And she thought that just by her kid getting that property, that it would create a situation where the spouse would be entitled to half of that property. And I was, I guess, happy. I don't know if the right word is happy, but I was pleased to inform her that in Washington State, and I guess I should back up, in Washington State there are two sort of different kinds of property. There's separate property and there's community property. When you're married and you get divorced, community property is split down the middle. Separate property tends to be kept by the party that owns it, whichever spouse owns that property. And in Washington State, inherited property is specifically designated to be separate property, which means it does not become community property. If there's a split up, the property does not get split down the middle. But, and this is a huge but, what's important to remember is that once you give your property to your kid, the way that they use it could change the type of property that it is from community property or from separate property to community property. If they commingle the funds in a bank account, for example, if they somehow use the property in a way that gives it a community property status, then you could potentially be out of luck. And if there was a divorce or something like that, then there could be a problem. I also told her, and this kind of goes outside of the separate property or community property aspect, that you may want to consider and think about. And by the way, this is a good reason why you want to talk to an estate planning attorney so they can tell you this stuff, is that if she would give her property to her kid and then her kid would pass away, the spouse would receive almost all of that property unless she gave it away in some other way. So it's important to remember that, once you give your property away like that you lose the control over it, that you lose the ability to keep it within your family and lose the potential ability for it to be even split up if your kid gets divorced. All right, so bottom line, to recap, inherited property is separate property. It stays with the person that it goes to unless it is somehow transferred or turned into community property. All right, so that's it for today. Once again, I'm Christopher Small. I'm the owner of CMS Law Firm. I am super excited that you're here. And if you have questions, let me know. You can call me, 206-659-1512. You can email me, chris@cmslawfirm.com, or you can leave a comment below, whether you're on Facebook, on YouTube, wherever you may find this or see me. Please comment and let me know what you think. Let me know if you have a question, and I can't wait to help you out. All right.